I'm Nancy Lindholm, President and CEO of the Oxnard Chamber of Commerce. We are thrilled and honored to have Michael Velthone, Managing Partner of Ferguson Case or Patterson LLC, with us today. This presentation is part of our Network of Knowledge series to keep the business community informed about issues affecting our local economy, government issues, pandemic resources, and much more. We'll get started in just a minute after I explain the format for today's program. So we'll receive Mr. Velthone's presentation and follow that with questions from the audience. At any time during the webinar, you can type your question in the Q&A module, which of course is the conversation bubble with a question mark in its center on the right side of your screen. We are recording this presentation and we'll make the video available after its conclusion. We've also uploaded the presentation slides to the handouts. Now let me introduce our distinguished speaker. As Managing Partner of Ferguson Case or Patterson, Michael administers a firm comprising nearly 30 attorneys at 2 offices, in addition to managing a robust practice in all aspects of business litigation and counseling, with an emphasis on shareholder and partnership governance and disputes, trade secrets, and employment law. Recognized by the Pacific Coast Business Times as a leading business attorney, Michael has represented clients on both sides of numerous business cases. In one recent case, an $80 million claim was made against clients accused of a fraudulent equity transfer in a publicly traded company. Michael successfully obtained a dismissal on their behalf. In another notable case, he secured a complete defense verdict on behalf of an aerospace manufacturer after a 3-week jury trial in a defamation and libel action. Such cases are the norm for Michael, who has also successfully litigated numerous consumer and wage and hour class actions and other employment claims on behalf of his clients. Michael earned his law degree magna cum laude from Georgetown University, where he also received a master's degree from the School of Foreign Service. A Ventura County native, Michael joined Ferguson Case or Patterson in 2001. He is a past board member of the Ventura County Bar Association and a former member of its Business Litigation Steering Committee. Michael is currently a board member of CAPS Media, the public access media organization in Ventura. He is also a member of the advisory board for California Lutheran University's Center for Economic Research and Forecasting. And when not practicing law, Michael is typically spending time with his wife and 2 children. He enjoys coaching his kids, and when there is time, boating, hiking, basketball, and golf. Michael, I'm turning it over to you.
Thank you, Nancy. I appreciate the introduction. Whenever I hear or read that introduction, it reminds me I need to go do my hobbies more often than I do. So in any event, welcome everybody. I find these presentations to be a bit awkward because I can't see any of you, so I can't gauge your reaction, whether you're interested or not. So I will do my best to keep you interested, even though I can't look you in the eye and make sure that you are. I'm sure that in any discussion of employment law these days begins with a 5-letter word that we are all very tired of, I'm sure, which is COVID, and COVID's impact on the workplace today, which not only is impacting us presently, but I think will have significant implications in the future once we are past sort of this phase of the pandemic. Because I only have about 30 minutes, this is going to be a top of the wave type discussion, which will be mostly aimed at highlighting issues for you to consider a lot of these issues have a lot of detail and nuance and other things that if you find yourself with one of these issues, I encourage you to do further research, access the available resources that you have, including the resources from the Chamber of Commerce. Particularly, I find Cal HR to be a very helpful resource, and other things. And certainly, if there is anything that is even more complicated, consult with an HR professional or an employment attorney. So with that being said, really when I look at COVID in terms of what the impact that it has had on the workplace, I tend to look at the law as sort of looking at relationships and various relationships. The law is simply tells us how those relationships should work. And obviously the primary relationship in employment law, although not the only relationship, is the relationship that you have with your employees. COVID has imposed significant concerns and issues on those employees, and as employers, we have obligations to them to make sure that they are treated fairly, that and the legislature has seen fit to pass legislation recently concerning leave and other types of things that you need to keep in mind vis-a-vis your employees. The second relationship is the relationship to the government or the public at large, which is really goes to sort of reporting notice obligations. If you have an incident at work, what are your obligations to report those? How does that work? What you should be mindful of. The third issue I'm going to touch on, which is an issue that existed prior to COVID, but I think is particularly relevant during COVID and will continue to be relevant after COVID, are some of the basic wage and hour issues that come up in a remote work situation. These are things that we saw becoming increasingly important even before COVID hit. Certainly, they're going to be as important, if not more important, as we go down the line and we move on from COVID. So that's sort of the overview of the COVID issues that I'll be discussing. And the first issue I'm going to deal with is the issue of leave. So, and I'm sure that all of you are aware of this, or most of you are aware of this, in terms of the law that was passed by Congress called the Families First Coronavirus Response Act. And that was passed earlier this year. And the gist of it is to require employers with fewer than 500 employees to give paid sick leave and paid family leave to certain employees under certain circumstances. This is on top of any other leave obligations, including paid sick leave, the California Paid Sick Leave Act. So these are additional requirements. They do not replace any existing or requirements that existed prior to COVID. One of those is for paid sick leave. So when the employee or is unavailable, can't come to work, and most importantly, is not able to work remotely. So one of the things you want to keep in mind is whether an employee can continue to work from home when dealing with these leave statutes. But when that employee is unavailable because of he or she is ill or must take care of a family member who is sick or ill or quarantined, then there are certain leave obligations, and I'll get to those in a second, that you have with regards to those employees. Among other things, if an employee's child cannot go to school or does not have daycare, and because of COVID, and the employee must remain home to take care of that child, there is an extended leave for that. And this has been going on so long that it may be that employees have already exhausted whatever leave was available to them, but it is an ongoing obligation of the employers. So what does the FFCRA require? And I'm just going to note that the FFCRA expires at the end of this month. So this may not be an issue that you have to concern yourself with after the end of the year. However, it is something that most people who are advocating for an additional stimulus believe should be extended past the new year, since we are still in the middle of the pandemic. So it is something to keep in mind, but technically it is set to expire in just a matter of weeks. So I'm just going to briefly go over what the FFCRA requires, and then we'll move on to other issues. First, it requires that the employer provide 2 weeks of paid sick leave when the employee is unable to work because they are quarantined or they are sick with COVID. That is, there's a capped daily rate of $511 a day, and therefore a capped total benefit of $5,000, basically $51,110. It's 10 days of work. So if you got an employee who's sick with COVID and they haven't exhausted this paid sick leave, they are entitled to that paid sick leave. So be mindful of it. That's on top of any sick leave they have available under California's paid sick leave law. Secondly, they are also entitled to 2 weeks of paid sick leave at 2/3 their rate because they have to care for somebody else, or their child is at school and they're unavailable. And that's, again, a 2-week period. So if your employee has to take care of somebody with COVID, because of a closure due to COVID, and again, this is an immediate family member, a child, or somebody who lives in their household, then they get 2 weeks of paid sick leave. That is capped at 2/3 of their pay, and it's capped at $200 a day. And then finally, and perhaps the most expansive one, is the 10-week of paid expanded family leave. When an employee who's qualified, they've been employed for 30 days, cannot come to work because they need to care for a child whose school or child care provider is closed or unavailable because of COVID. Again, that is a 2/3 pay, and it is capped at $200 a day. So that 10 weeks is on top of the 2 weeks above. So basically, the employees take their 2 weeks, and then if they have a child that they have to take care of, that 10 weeks follows after those 2 weeks. So keep in mind that those obligations are still existent, and there's a reasonable chance that they will be renewed in the latest stimulus package, although I understand in the bill that McConnell put up yesterday, it is presently not. So please keep in mind, follow that development to see if it continues. Now, if an employee can telework, which means they can work from home, and you have work to do and you allow them to work from home, there are no extenuating circumstances, then these leave rules don't apply. So if you can set up an employee at home who has to take care of a child because of childcare and they can work from home, then the extended leave does not apply. Same with other issues. So keep in mind that telework is a good solution if you need an employee to continue working if you haven't already arranged it. Also, if the employee is furloughed, the leave obligations do not apply. Again, the FFCRA is scheduled to sunset at the end of the month. Reports are mixed as to whether Congress is going to extend it or modify it anyway. Right now, as I said, the latest bill that's being debated, it is not extended, but keep an eye out for future developments. So recently, California passed a supplemental paid sick leave program in September, which fills in the gaps that were created by FFCRA. And in particular, it covers employees with more than 500 employees nationwide. So I don't know if there's any people out there who this deals with, but if you employ more than 500 employees nationwide and you were therefore not covered by FFCRA, you are covered by California Supplemental Paid Sick Leave. Again, basics without getting into the technical details. If an employee is unable to work because of a quarantine, because of a diagnosis, etc., then this supplemental paid sick leave would come into play. The other place it covers is with healthcare workers. There was an exemption from FFCRA for certain healthcare workers who are essentially in the chain of providing healthcare. So not just physicians, but nurses and staff who have some involvement with the provision of healthcare. So the California Supplemental Act now brings those people in, and they are now covered by California law, even though they are not covered by federal law. Again, the leave requirements are similar to the FFCRA, but there is a special unique provision with regards to part-time employees. I won't get into the details about what that might look like. If you do have a part-time employee, you should consult resources to figure out what is available to them. As with anything these days, California decided in connection with this law that, gee whiz, it would be nice to make the pay stub even more complicated and indecipherable to employees. So let's require that the employer put on a wage statement or a separate statement attached to the wage the amount of available leave under this act to the employee. As you probably know, there are penalties and other litigation risk with regards to pay stub requirements. And so if you have not done so already, you should talk to your payroll provider and make sure that you are complying with this pay stub obligation. There is also a new law that is applicable to the food sector industry, which is basically wage orders 3, 8, 13, and 14, and others who work in a food facility or delivering food. It's essentially very similar to the Supplemental Leave Act. So if you have employees or if you work in those industries, you should make sure, be aware of that and understand your obligations under that particular act. As with the FFCRA, the California Act expires on December 31st or when the FFCRA expires. So if it is renewed, the FFCRA, then California supplemental leave will also be renewed and will continue. So again, keep posted on developments on that front. So one of the things that I think all employers are dealing with, and we're certainly dealing with it at our law firm, although we've been fortunate so far, is what do we do when an employee comes to work with COVID? And there are all sorts of issues that we never really have to think about. We have, it's not unusual, for example, to get a phone call from an employee that says, my sister was just diagnosed, tested positive, and I was with her over the weekend. What do I do? I've even fielded calls from people who saw somebody who saw somebody who saw somebody who tested positive. And there is obviously a healthcare component to that question about keeping your employees safe. But there are now legal obligations with regards to notification when an employee is diagnosed with COVID. And this is a law that was passed in September. It's a California law, and it's AB 685. And essentially, if an employee is diagnosed with COVID, so one of your employees says, I have tested positive for COVID, and that employee had been in the workplace during the potential infection period. So obviously, if the employee is working remotely from home and hasn't been in the office for weeks, then this would not necessarily apply. But if the employee has been in the office and there is a potential for exposure, and they are diagnosed or test positive for COVID, then there is an obligation on the employers to provide written notice to the employees of the infection and to alert them to that infection. Basically, it's anybody who may have been exposed to that person. So if they were in the same work site as the infected person within the infectious period, and they might have been exposed, you should provide written notice to them of the infection. Now, obviously, there are privacy concerns with regards to the infected employee, so we do not trumpet out all the details of everything, but we let them know that they may have been exposed. The other thing that you are obligated to advise your employees under these circumstances is the benefits that they are entitled to, including workers' comp, the leave act, the paid sick leave, and also advise them of the anti-discrimination, anti-harassment, retaliation policies so that if they do avail themselves of these issues, that they will not be retaliated against. You also want to advise the employees what you're doing with regards to disinfecting the workplace and taking precautions against any further exposures. So, for example, you would advise the employees that you have hired an outside company to come in and disinfect the workspace where the infected employee worked. You may segregate it or quarantine it for a period of time, whatever. Consult CDC guidelines, consult the experts as to what you should do, and then tell your employees that you are doing this. So that is a requirement now. It's not just good practice. Now, this law does not require you to go through this when an employee calls and says, hey, I may have been exposed. I was at my mom's house over the weekend and she just tested positive. It's only triggered when there is an actual diagnosis or an employee test positive. Now, if you have what's called an outbreak, so if you have 3 COVID infections in the workplace within 14 days, you are considered to have an outbreak. Sounds rather alarming, and you are advised to report that to the local healthcare agency, Ventura County Public Health, if you're in Ventura County. You are also required to report an infection, if you have more than 5 employees, to your workers' compensation carrier. So when an employee says, I have COVID, report it to your carrier. There is a rebuttable presumption under the law that the employee contracted COVID in the workplace so that they would be eligible for workers' compensation benefits. Of course, that doesn't mean a rebuttable presumption does not mean that they are entitled to benefits. It just means that the burden shifts to the employer or the carrier to demonstrate that the employee contracted COVID outside the workplace. But regardless, you have to report that to your carrier within, I believe it's 5 days of being advised of the infection. Finally, I just want to alert you to the extent that people, particularly in this most recent shutdown and with the end of the PPP program for a lot of people, which has sort of eliminated the incentives to keep a fully engaged and fully employed workforce. If you're looking at furloughs or reductions in force, so one option that we actually took advantage of is EDD's work share program, which allows you to have your employees to receive unemployment benefits if their work hours have been reduced but not eliminated because the work has been, there's less work to do, and instead of letting people go, you've simply decided to reduce people's work hours. Now, we ultimately did not take advantage of it. We did apply to make sure that it was in place should we go through that program, or should we decide to reduce people's hours. But that may be something that you want to look into as a benefit to your employees if you are considering reducing the hours of your employees, but not necessarily furloughing them entirely. So I'm going to talk about something that's I've been talking about for many years, and that is remote employees and what are the issues that you need to consider. And I think many of you will agree that if you have employees that are working remotely, many of those employees are very happy working remotely and would be interested in continuing to work remotely even after the pandemic is past us. This was a trend that was happening before, and it certainly has been accelerated, and I think employers are going to be dealing with many of the issues that arise when you have employees working at home. And I just want to give you a survey of what those issues are so that you can keep in mind and make sure that from a compliance standpoint, you've identified all the things that you need to identify. First, timekeeping. When employees do not come to work, the workday tends to be much choppier. Employees may work an hour or two in the morning and then work at night, and it's not simply a matter of reporting to work and then working through the day. And that raises timekeeping issues, especially for non-exempt employees. So you need to make sure that they keep accurate time. You don't have remote timekeeping systems. You may need to make sure that they clock in and clock out. For example, for meal breaks, they need to keep track. And if you know that people are working and not putting it down on time, then you might get an off the clock problem. And so what you want to do is have very clear policies about how they record time, and to make sure that they are recording all time worked. And also, I think it's, to this degree, it's important that you try to keep some semblance of a normal workday, even if they are working remotely. So to have regularly scheduled hours to make sure that they are there, and try to stick with those hours. But timekeeping is a really difficult one because people are, the workday becomes much more fragmented when people are working at home. The other issue that I see is reimbursement, and that is that the employees will incur some additional expense when they work at home. And that additional expense is the obligation of the employers. We're all familiar with cell phones, and hopefully if you require employees to use cell phone, that you have a cell phone reimbursement policy. But with regards to remote work, things like Wi-Fi, internet, other types of marginal costs, or even fixed costs where some of it is allocated towards work uses, you may want to consider developing a reimbursement policy for those expenses. So ones I typically see are, related to the internet. If they're using their own laptops, that's another issue that you may want to consider. So think about all of the resources that they are using, office supplies, those types of things, and make sure that you are reimbursing your employees for their expenses that they have incurred to do the work at home. Another issue is workplace safety. OSHA has some requirements. They're very generic about making sure the workplace is safe at home. I think it's always just a good idea to have some guidelines about what the workplace should look like at home, make sure that the employees are working safely. Another issue is meal and rest breaks, and that's just not a problem with regards to working remotely, but also just generally overall. I encourage you to make sure that your employees are taking their meal and rest breaks, and that comes a bit in with the timekeeping, but it's going to require some additional monitoring on your part so that you don't run into this issue. Another issue is confidentiality, and that is to the extent information that normally remained at the workplace is now at home. And if you have anything such as HIPAA concerns, trade secrets, stuff that you don't want being public, you want to make sure that you have really good policies in place about how to handle those materials so that you don't run into a problem with regards to those issues. Finally, one of the things that I think we are all dealing with, or all will be dealing with, is the precedent of remote work. We have accommodated many employees to work remotely because that has been the way that we can get things done in this environment. Once COVID is gone, the need for remote work will disappear. But in many instances, we'll have demonstrated that remote work is feasible and employees can remain very, they can do a great job while working from home. This issue is going to come up when employees want the accommodation of working at home because of some disability or other condition. So you need to think about what jobs in the future you think it is not essential for the employee to be at the office or at the work site working. You need to look at to the extent you don't want employees working at home, you need to take a look at your job descriptions and make sure that they describe a job that requires them to be in the workplace. Otherwise, you might find yourself in a situation where you are compelled under the ADA or FEHA to allow an employee to work at home. So this is something that I think we're going to see more and more of in the future. So just be mindful of that. I'm going to briefly talk on the ABCs of independent contractor. I only have a little bit of time left. This obviously has been a big issue recently. If you're not familiar with the ABC test, the Dynamex test, essentially it substantially limited which workers can be called independent contractors. And in order to be classified as an independent contractor, each of these three conditions must be satisfied. One of the most difficult ones is the second one, which is basically they have to be working for you and not for your customer or clients or end user. So if you have subcontractors or people who are coming in who are interfacing with your customer base, they're going to be employees. It's going to be very difficult to classify them otherwise. It really is getting to the point where this simple test, and it does seem simple when you read it, is looping in a lot of occupations and other businesses that up until now were considered to be independent contractors. And so it's raised a whole bunch of issues. So if you're not familiar with this issue and you do employ independent contractors to do work that may or may not be independent contractor, you certainly want to take a look at this issue. Some recent developments in this area, California legislature passed AB 2257, which created new exemptions from AB 5 and the ABC test. And in particular, what you're seeing, and I think you saw it with Prop 22, is a lot of business pressure, not only from the Chamber of Commerce, but also from industry groups to modify and create exemptions for AB 5. What's happening now is just a hodgepodge of legislation, and I can tell you, if you read AB 2257, I find it to be in many ways impenetrable on some of these things. And it's my firm belief that, especially in the area of employment law, you shouldn't have to hire an employment lawyer to tell you what the law is. This is one of these situations where, however, where it is very complex. There are lots of tests. It is not straightforward. But keep in mind that there are many now exemptions from AB 5, and you ought to just do a little research to see if any of your employees who you'd like to classify as independent contractors may qualify. I represent a musical group or musical organization, and they hire musicians to come in and play concerts. Just one, they hire basically a symphony to do a concert, a one-off. They've just been paying these guys a day rate, but gee whiz, what do we do now with AB 5? Well, now there's been some relief, but even those rules are terribly complicated and are not frankly easy to understand. So just be mindful that there are exemptions to the ABC test, particularly in things like the professions and other things. There is this business-to-business exemption, which I don't find in most cases to provide really much of an exemption, because it simply seems to me to restate most of the ABC test, but that may be something that you could take advantage of. And that really happens when you contract with a separate business to provide services to you. If they are truly an independent business and they provide their services to others as well as to you, and they control how they do the business, how they do the work, there's a good chance you can still call them an independent contractor. Keep in mind that even if you are not subject to the ABC test, you are still going to be subject to Borrello, which is a case from days of yonder, which has a much more multifaceted, fuzzy test as to whether an employee is an employee or not. So it's not simply a matter of exempting yourself from AB 5. You still need to take a look at the Borrello test to make sure that you're not falling into an independent contractor employee situation. Finally, there is a significant amendment to CFRA this year. CFRA, for those of you who are unfamiliar, is the California Family Rights Act. Up until now, it applied to employers with 50 or more employees. It's basically coterminous with the federal law, FMLA, FMLA. But now it applies to employees with more than 5 employees. So if you find yourself with employees from 5 to 50, you're now going to be subject as of January 1st to the CFRA, which provides for unpaid leave rights to employees who have medical conditions or have to take care of people with medical conditions. It's a rather complicated act. So if you are one of these employers, you should brush up on the CFRA and what your obligations are. And most notably, you should change your policies and your handbooks. Make sure that you have the right posters out as of January 1st so that you can make sure that you're complying with its obligations. The other thing that this does is it expanded the definition of family members who are covered by the CFRA. So now if you have to leave to take care of a grandparent, for example, that could qualify you for leave under the CFRA. And it's much more expansive now than what's available under the FMLA. So that up until now, those two were pretty much mirror images of each other. Now the CFRA is a bit different. And so even for those employers with more than 50 employees, you might find yourself with an obligation under the CFRA without a corresponding obligation under the FMLA. And that could create some questions as to whether leave under the CFRA does not qualify for leave under the FMLA, whether or not you get credit for that leave if somebody wants to take a second leave under FMLA. We'll see how that plays out. Finally, I just want to give you some friendly reminders. These are things that you should always generally be mindful of around this time of year when you're going to these wonderful employment law updates. First, one thing I just want to remind you, I am still seeing meal and rest break issues pop up, even with employers who are vigilant about them. I generally have a sort of a recommendation for employers on how to handle these things. It is something that's seemingly so simple, it can be really complicated. But one of the things I recommend is to make sure that your employees verify every payroll, that they sign off on their timesheets, that they also verify that they were provided all meal and rest breaks that they were supposed to, and that they should, and to confirm that they have identified any breaks that they were unable to take, and to then explain, explain why they were unable to take them. This can help. It's not a panacea, it's not a cure-all, but certainly if somebody later on comes down and says, I did not receive meal breaks, you can have at least contemporaneous confirmation from them that they at least verified to you that they had received all the breaks. Handbooks, with a lot of these changes, CFRA and other things, you're going to need to update your handbooks. Harassment training for all employees, that's something that was sort of kicked down the road because of COVID, but it's now due. So if you have not done it, you should do it. Finally, we also have the increase in minimum wage this year, which also has a corresponding impact on the minimum salary requirements for purposes of classifying employees for, excuse me, for exempt status. So if you have any exempt employees, make sure that they are being paid a salary of at least 2 times the minimum wage. I think it's like 54 and 58, depending on the size, if you have more than 25 employees or not. And then finally, arbitration provisions. The legislation last year with regards to the enforceability of arbitration provisions, that has been enjoined by a federal court, but it is still out there. I still recommend that employers consider arbitration provisions. There are pros and cons. The primary pro, in my estimation, is the ability to waive class action rights so that you're not dealing with class actions, particularly in the wage and hour arena. But even though that legislation, AB 51, has been stayed, it's a good idea to comply with it, because that legislation, ultimately, that lawsuit may not be successful, and it may be determined that the California legislation is valid under the FAA. So take a look at your arbitration provisions. If you are just doing what you've always done for the past 5 years, take a look at AB 51, make sure that you're doing it in compliance with AB 51. So that's it. There's a lot more that's happened in the employment world this year, but I tried to pick topics that I thought most of you would have some relevance to. And there's certainly a lot more to dive into with each of these. So if you have any questions or any concerns about specific issues, again, I encourage you to speak with or consult HR California, talk to an HR professional, or an employment law attorney if it's a complicated issue. And with that, I will turn it back over and ask for if anybody has any questions that I may be able to answer. And thank you very much for your patience.
Michael, thank you so much. Yes, a whole lot to consider, as seems to be the norm in the state of California. Again, if you'd like to ask a question, please go ahead and type it in the question module at this point in time. We have one question to start off with right now, and it regards working from home. Do you think this will become a normal protocol, and will California labor laws need to be amended to incorporate these practices?
So right now, employers have the right to identify the work site that the employers work. And if you want an employee to come to work at the work site, then that is your prerogative as a baseline question. Where we see, so I think it will still continue to be the choice of the employers, that the employers, and I think many of us have figured out that there is even though employees can be productive at home, there are many situations where you lose the benefit of that daily contact, the serendipity that comes with just being in the office together, that ability to share ideas, to communicate. It's hard to replicate that remotely. I also think that in the employment context, one of the things that we found is that, work culture is very, very important. And it's difficult to maintain that culture when people are working remotely. I think that work culture is one of the most important aspects of a successful business. Having people that feel invested in your business, invested in the workplace, feel good about what they do. That's much more difficult to achieve when people work from home. At the same time, providing that flexibility might be something that employers look to distinguish themselves from others. And so it may be the marketplace starts to dictate that providing for remote work is something that's going to be something that we have to do to attract the talent. When that happens, I do think that there will be a lot of these issues that are kind of discussed or dealt with in generalized ways. I do think because the California legislature is they can't, there's so many solutions to problems that exist that they will then address some of these issues that we've talked about with home offices. And there may be specific legislation that guides employers on how to handle those things. OSHA may become a bigger issue. Reimbursement may become a bigger issue. One of the things I think that we're going to deal with is when the employer does not want to allow an employee to work remotely, but an employee requests it as an accommodation for a disability. And that's a situation I think we're going to see quite often. And as I think most employers know, employees are very good at identifying disabilities to get things that they may want. And so I think you're going to see a strategy of a lot of employees saying they need to work from home for certain reasons. And we're all going to have to work through that challenge because there are no bright lines about how to do that test. It is very fact-based. So I think we're going to see a lot of pressure and some litigation in that area in the coming years.
Great, thank you, Michael. And just from a follow-up question to that I've received at the chamber regarding remote workers, if they are 100% remote, we've been informed that they must be provided with one of those employment posters for 2021. Well, I imagine in 2020 was the same situation. So do employers have to physically provide them with one of those posters? Is there an electronic version they can send? Do you have any comments on that?
Yeah, I mean, I personally think it's absurd to require the employer to provide a poster to post it in the employee's home. I mean, the employee doesn't want it, nobody wants it. I believe that there are some provisions, and Nancy, I'll follow up with you on this, that allow you to transmit the information electronically or to provide it in a different format. But let me get back to you on that particular issue. I don't know of any employers who have put up posters in everybody's home who's working remotely, and that I think if it is presently required, and I believe it's not, I think that would be something that would be addressed shortly because that does not seem to make sense from the employer side or the employee side.
Okay, great. All right. Again, are there any other questions? If you would please quickly type them in the question module. I'm not seeing any others pop up at this point in time. So it appears that you've done an excellent job covering all the bases that there are to cover under California employment law. Again, it's as you know better than anyone, Michael. This is an ongoing, ever-changing field that I'm sure provides you with a lot of job security. Do you have any other final comments you'd like to add?
I don't. I think that, well, I say I don't, but then I have one, right? Well, that's typical lawyer right there. I do think that it's really important for people that if they don't already to subscribe to things like HR California or other things that can keep you abreast of these developments. You know, they go into effect and it's not like the California legislature is very good at publicizing a lot of these things. And you don't want to get caught with a problem. And in particular with PAGA and some of the other enforcement mechanisms out there, there are a lot of attorneys who are hunting for cases, and they can happen even when they're just innocent mistakes. So it really do need to be proactive. And if you're just simply tuning in for the year-end summaries, I strongly recommend that you subscribe to a service that keeps you more up to date because these changes are happening quite rapidly.
Okay, great. Thank you again very much, Michael. We really appreciate the time and effort you put into your presentation today. And to all those who joined us, thank you. I hope you gained some valuable knowledge about what California employers are facing in the coming year as well. I would just like to remind everyone that the Oxnard Chamber is a reseller of labor law compliance materials produced by the California Chamber of Commerce. You can log into our website at oxnardchamber.org to order employment posters and other HR products. This has been an extremely, extremely tough year for the majority of us. I hope you can all find a safe way to appreciate the upcoming holidays and to welcome in the new year. And thanks again very much for joining us today. Have a great rest of your day. Bye-bye.